President Biden addresses the nation at the State of the Union. The DNC changes its primary calendar to put South Carolina first in line. And this upends the established order that has been in place for 50 years that has put the Iowa caucuses first. We're going to discuss why the DNC made this decision. And then I'm going to dedicate the rest of the show to interviewing Professor Kurt Lash, a renowned constitutional law scholar and professor of constitutional law at the University of Richmond. We're going to talk about the upcoming affirmative action cases, the Creative 303 free speech case, and the punishment clause of the 13th Amendment that has gotten so much media attention over the past couple of years. I'm Julie Hartman, and this is Timeless. Hey friends, it is Thursday, February 9th, 2023. I hope that you are having a great week. I would like to remind you to please like and comment and subscribe to this YouTube channel, and please follow me at Julie R. Hartman. As I mentioned earlier this week, I have started doing these daily 60-second news clips, and today I think it will be especially important for you to watch that 60-second news clip because in this episode I'm going to go through the news pretty quickly because, as I mentioned in the introduction, I am interviewing a renowned constitutional scholar, Kurt Lash, on various issues that are coming before the Supreme Court later this year. And I want to give him a lot of time because it's so important that we understand these cases. Sometimes we as Americans don't pay much attention to the Supreme Court because I get it. A lot of the issues are complicated and it flies over our heads. But this is our country. All of these things affect us. And so Professor Lash and I will be talking for a little bit about these cases and try to make them as accessible as possible. But first, I have to acknowledge that President Biden delivered the State of the Union 2 nights ago. Now, some of you have been writing to me asking why I haven't commented more on this address. And frankly, I'll be honest, I don't really have that much to say about it. It was kind of a snooze. And really, I think the scandal of the State of the Union address wasn't so much what was said. Certainly, there were some sort of eye-rolling moments when President Biden was droning on about airline and luggage problems at the airport, and when he accused the Republicans of wanting to sunset Medicare and Social Security, even though Kevin McCarthy had said that that was not the case as far as Republicans' budget proposals. So yes, there were some of those moments, but really a lot of it was quite dull. And he barely talked about the fentanyl crisis. He didn't take responsibility for it. He did not discuss all of this information that has come out about the corruption of the FBI and the Twitter files. He didn't touch the issue of schooling. It has recently come out that 1.2 million public school students have left public schools in the wake of the pandemic. Our test scores across the board in reading and math and science are the lowest they've ever been in 40 years. And so many of our schools are infected with radical gender and racial theories. So he didn't touch that. And again, I think that's more of the really big story pertaining to the State of the Union rather than what President Biden said. Now on to a bigger story regarding President Biden. The Democratic National Committee has voted to revise the party's nominating calendar for 2024 to put South Carolina first in line. And this was done to grease the wheels for Biden in the upcoming election. As background, primaries and caucuses are how each party selects which candidate gets that party's nomination for President of the United States. And up until the 1970s, the parties basically decided the nominee through their own nominating conventions. And these conventions were mostly filled with party elites and insiders. Primaries, though, primaries as we know them today, I should say, became more popular in the 1960s. But even then, the party did not have to abide by who the primaries selected. it was only after RFK's assassination in 1968 that the parties agreed to make the primary outcomes more binding of who the presidential nominee would be. So for about half a century, the Iowa caucuses have been first in line. And as you can tell from the name, Iowa, unlike other states, doesn't have a primary, but it has a caucus. Caucuses are different because they have all of these weird rules. For instance, you show up in a gymnasium or wherever the caucus is being held, and if you support X candidate, you go and stand in one part of the room, and they figure out how to allocate delegates to various candidates based on the amount of people who showed up. The rules are really complicated and frankly kind of bizarre. But traditionally, they do these Iowa caucuses first. Then the New Hampshire primary is second, and South Carolina is third. And this order has historically been because Iowa and New Hampshire are not super ideological states. So if a candidate wins overall in these states, it's a good barometer that you might be an appealing candidate in the general election. Primaries tend to attract the most committed and extreme voters who will take the time to show up and stick their neck out for their desired candidates. So putting these more neutral states first, again, better indicates who would be the best, most broadly appealing candidate. With each primary, candidates are given a number of delegates proportional to what percentage they win the primary by. And this makes primaries different from presidential elections. In a presidential election, if the candidate gets a simple majority of votes in that state, they win all of the state's electoral votes. But in a primary, for instance, if Joe Biden wins 50% of the vote, Elizabeth Warren wins 30%, Pete Buttigieg wins 20%, they will each be given a different number of delegates. And at the end of the primary season, the party adds up all of the delegates, and whoever has the most wins the nomination. So according to these new DNC rules, the primary will first be held in South Carolina on February 3rd, 2024. And after that, the new order is going to be New Hampshire and Nevada on February 6th, Georgia on February 13th, and Michigan on February 27th. Now, political parties are allowed to choose their own primary order and nominating rules as long as it comports with state law. But people are criticizing the DNC for this decision, A, because it upends the established order that has been followed for decades, and B, because, as I said earlier, it greases the wheels for President Biden to win the nomination. Biden in 2020 finished 4th in Iowa and 5th in the New Hampshire primaries, which was not so good for him. So they are putting South Carolina first because South Carolina, has a high black population, and President Biden is quite popular among black voters. So what's really going on here is that the DNC is trying to secure him the nomination by ensuring that he gets a big win out front in South Carolina. Because if you get a big win at the start of the primary season, you are more likely to just get more media coverage, more donations, and more funding from your party. It creates this momentum. This decision is good for President Biden and his supporters, but I think that it is bad for the Democrats in 2024 because though President Biden may get the nomination, polls have been showing that people on both sides of the aisle don't want him to run again. I am honored to welcome Professor Kurt Lash onto the show today. He is a constitutional law professor at the University of Richmond who specializes in the post-Civil War Reconstruction Amendments. For a reminder, it is the 13th, 14th, and 15th Amendments. Professor Lash is also founder and director of the Richmond Program on the American Constitution. He has authored many books and pieces of writing on constitutional law, and he is currently writing a book called A Troubled Birth of Freedom: The Struggle to Amend the Constitution in the Aftermath of the Civil War. Hello, Professor Lash. Thank you very much for coming on to the show.
Julie, it's a pleasure. Happy to be here.
It's nice to see you again. We met in person a few weeks ago when you were out here in Los Angeles filming a PragerU video. And so it's nice to see you again on the screen. And I just want to tell the audience that before we went on the air, I complimented this office of yours that is so regal. and academic looking. I love the dark wood and the busts of, well, who is that over your right shoulder?
Okay, so over here we've got George Washington and a good Virginian, and I'm talking to you from Richmond, Virginia. Then directly behind me, I guess it would be on this end, there at the mantelpiece, you have James Madison, another Virginian, and next to him is Frederick Douglass, one of the most important players in the Reconstruction Amendments and the refounding of American freedom after the Civil War. So they inspire me, or at least I'm hoping that they do. I
should have been able, at the very least, to identify George Washington there over your right shoulder. I thought it might have been Cicero for a minute. I'm going to blame it on a little bit of a blurry screen. I should be able to ID him though. So as I indicated in my introduction at the start of the show, which you did not hear, but the audience heard, I'm going to talk to you today about the upcoming Supreme Court cases. Probably we're going to spend most of our time talking about the upcoming affirmative action cases, but I'd also like to ask you about this Creative 303 free speech case about the woman who does not want to design wedding websites for gay couples because she has a religious objection. And then finally, I want to ask you about the 13th Amendment, which abolished slavery in the United States. And it has this punishment clause, as you very well know. And the punishment clause really garnered some attention in the summer of 2020, really because of the Netflix documentary 13th. And people have a lot to say about what it may have to do with the treatment of incarcerated people. So we're going to get to that. Just wanted to give the audience a little bit of a primer. But first, let's dive into these upcoming affirmative action cases. We have Students for Fair Admissions versus Harvard case coming up to be decided on later this year. And then the Students for Fair Admission versus North Carolina, which is basically the same case, but it applies to public universities instead of private university, which Harvard, of course, is. But let's go back to what I consider to be the landmark case which allowed affirmative actions in the first place, and that's the Regents of the University of California versus Bakke in 1978. By the way, I know I'm talking a lot here at this introduction. Audience, please know that you will be hearing Professor Lash talk much more throughout this interview than I am, but I just want to give a little bit of a background for our listeners on this case, and you can tell me if I'm characterizing it accurately. So a 35-year-old white man, Alan Bakke, back in the 1970s, applied to UC Davis Medical School twice, and he was rejected both times. He had higher test scores and a higher college GPA than most of the applicants. But the thing in question here is that the UC Davis Medical School reserved 16 out of 100 slots for minority candidates. And so Mr. Bakke alleged that this violated the Equal Protection Clause of the 14th Amendment in the Civil Rights Act of 1964. Do I have those facts right so far?
That's correct.
Yes. So the Supreme Court upheld in this case that affirmative action should be allowed because it takes race into consideration as one of the factors when evaluating a candidate. But the court said that the quota system was unconstitutional because it makes race the sole criteria for evaluating a candidate, and it excludes candidates solely on the basis of race. So I understand why the court would say that the quota system is unconstitutional. I'm a little bit confused about the argument that the court used to uphold affirmative action. As background, the court has adopted different levels of scrutiny pertaining to certain equal protection cases. The equal protection cases pertaining to discrimination on the basis of race, the court says that the law can discriminate on the basis of race if there is a clear, narrowly tailored relation to an important government interest. And so in this case, the court said that diversity was that important government interest that would make affirmative action, which does discriminate on the basis of race, permissible. So finally, I am done talking. I want to ask you this question. The Equal Protection Clause in the 14th Amendment says that you can't deny people equal protection of the laws, period. It doesn't say that you can deny people equal protection of the law unless there is a compelling government interest that allows you to do so. So don't these standards that the court has, which aren't really grounded in law, don't they kind of potentially allow people to read whatever they want to read into a statute?
Well, the difficulty in Bakke was a question that they'd struggled with and continue to struggle with. So you're quite right to say that they've come at it from different directions. I think there are some clues in the text of the Constitution that can help resolve this case, but it comes at the court with a long history of struggle over race in the Constitution. And so in answering your question, I'd like to go back just a little bit and talk about what the court was struggling with when they first addressed this issue in Bakke. And then we can move forward into later cases and then ultimately to the current Harvard and UNC case. As you mentioned, this is an issue that involves the Equal Protection Clause of the 14th Amendment. That amendment, adopted soon after the Civil War, is part of the 14th Amendment. It's part of Section 1 of the 14th Amendment, and it declares that no state shall deny any person the equal protection of the laws. And not too long after its adoption, the court took the position that it didn't allow exclusion of Black Americans from juries. I mean, outright discriminatory actions targeting Black Americans were generally ruled to be unconstitutional. But as you also probably know, in cases like Plessy in the late 1800s, the court ruled that separate could be equal, that maybe states could segregate individuals on the basis of race and use racial classifications in assigning them places in railroad cars or transportation, things along those lines. And as long as they separated them in an equal kind of way, that didn't violate the Equal Protection Clause. That was overruled by the court much later in the 20th century in Brown v. Board of Education. In Brown v. Board, the court said no, if segregation actually is ultimately discriminatory and it is not justified under any kind of extremely compelling interest by the state, and so therefore they invalidated segregation or separate but equal. Then a few years after that, in Loving against, about a decade later, in Loving against Virginia, the court went even further than Brown and said that any racial classifications that are used by the government are odious to a free people, just to use the language of the court. And so therefore they have to face the most strict judicial scrutiny and will be upheld in only the most extraordinary of circumstances. And for example, there might be, and this is something the court uses sometimes in its opinions, perhaps there's a race riot at a prison, and prisoners have to be temporarily separated on the basis of race. Well, that's using race, but it's an emergency situation, and it's temporary, and for that temporary purpose, it can be upheld. But what about situations that are not so fraught with physical peril as a race riot, but what if it's a situation still involving a racial classification where there's no attempt to harm members of a racial group, but they're using affirmative action as the government developed through the 60s and 70s, and they're trying to actually give an advantage to members of a racial group that has faced discrimination in the past. That is challenged, of course, because it raises an equal protection interest in that you're giving an advantage to some people on the basis of their race, but you're not giving an advantage to other individuals, like that white applicant to the Davis medical program that you're talking about in Bakke. And so the court had to decide whether or not the strict scrutiny requirements that required striking down any program that wasn't furthering a compelling interest and doing so in the least discriminatory ways, whether or not an affirmative action program in a university could meet strict scrutiny. And in the Bakke case, you had that reservation of 16 seats out of 100, and the court invalidated it. A majority of the court ruled that that quota system was in violation of the Equal Protection Clause, and it was an unjustified classification on the basis of race. However, a single justice, not the court as a whole, but a single justice, Justice Powell, offered the fifth vote for invalidating the case. And in his opinion, he stated that even though I think that this quota program at the university is unconstitutional, I don't agree with my colleagues that racial preference programs are always unconstitutional. And he cited as an example a so-called Harvard program that used race as one factor among many. And according to Justice Powell, and only Justice Powell in the Bakke case, that kind of program was not as poisonously discriminatory as a quota system. It was still treating individuals as whole individuals with lots of aspects to their personality, with race only being one factor among many, and that taking that one component among many components into consideration furthered what he called the compelling interest in assembling a diverse admitted class. So this became known as educational diversity, affirmative action programs that are seeking to create a diverse admitted class. It was just his opinion, but he provided the fifth vote. And so in the years following Bakke, even though we didn't hear anything else from the Supreme Court, universities and colleges simply presumed that Justice Powell's fifth vote was now going to be the standard that the court was going to apply in the future. And it wasn't until 2003 that the Supreme Court, a majority of the Supreme Court in the Grutter case, the University of Michigan case, finally officially adopted, a majority officially adopted Justice Powell's view that educational diversity can be a compelling interest and can support an affirmative action or a racial preference program as long as race is just used as one factor among many. So that's the general background, and now we can continue to explore this issue in the current cases.
Thank you for that general background. It was much clearer than my long-winded, nerdy introduction. I told Professor Lash before we started the interview that if this career doesn't work out for me, I want to go to law school and become a constitutional lawyer and gun for the Supreme Court. So I was combing back through my con law course in college, and I think all of this is fascinating. So before we move on to those cases, I want to ask you, how does the court decide what constitutes a compelling interest? Certainly here they've said that diversity fits that criteria. Perhaps I'm wrong, but it seems to be subjective. Because if you look at the later case, Gratz versus Bollinger, and you just talked about Grutter, I always pronounced it Grutter. So see, I'm learning. I gotta get this right before I apply to law school. In Gratz versus Bollinger, there was the University of Michigan undergraduate point system contested. And as background, the University of Michigan gave minority students an additional 20 points as part of a point system on how they evaluated applicants. And someone said that this violated the Equal Protection Clause, and the court agreed that it violated the Equal Protection Clause. So why there? Didn't they say that that point system constitutes a compelling government interest? That point system helps facilitate the diverse student body that you were just discussing. Why was that struck down? But then the affirmative action policy in the 1978 case was upheld.
And now you're cutting directly to the point of the subjective aspect of equal protection jurisprudence. So let's dig into that a little bit. Now, first of all, as you mentioned in your introduction, for any kind of use of racial classification by the government to be upheld, it has to meet the strictest of judicial scrutiny. And this is sometimes called, well, it's generally called the strict scrutiny test. There are two components to it. And understanding these two components, I think, will help answer the question about why one program was upheld in the Michigan case and why another one was struck down. First of all, to use race, the government has to justify its use of race for the most compelling of interests. And you asked, well, how do they go about defining compelling interest? There's been no definition. the court has used analogies saying compelling interest are the highest interests that government can have, generally having to do with life, health, and safety of the highest order. And there are lower standards. Sometimes the court requires nothing more than an important interest, say in a sex discrimination case. Sometimes the court requires nothing more than a mere reason or a rational basis for, say, an economic regulation. So they have different standards of review, different hurdles that the government has to achieve. And if they want to use race, that is considered to be one of the most dangerous things that government can do. And so therefore, they have severely restricted what counts as a compelling interest. And one of the issues before the Bakke case was whether or not affirmative action could meet the compelling interest standard. One of the justifications for affirmative action programs was that it was necessary to make up for general societal discrimination. Maybe there wasn't any proven discrimination that a university was trying to resolve or to remedy, but nevertheless, we should take into consideration histories of discriminatory treatment of different groups over time. And according to the court in the Bakke case, that mere societal discrimination does not justify the use of race, because you're not dealing with any kind of specific discrimination that you're remedying, but you are imposing a direct instance of discrimination against individuals who are applying to the program but might not be a part of the targeted or identified racial group. So the court ruled that making up for mere societal discrimination was not compelling. Well, what is educational diversity, and why should that be considered a compelling interest? At the time in Bakke, there was only one justice who thought that did count as a compelling interest. It wasn't until 2003 that a majority of the court determined that, in fact, they agreed with Justice Powell that educational diversity, or assembling a diverse class, was as compelling as any other government interest involving life, health, and safety. Now, I don't think that all of the current members of the current court agree with that particular position, and I'm wondering whether or not they're gonna back away from that in terms of educational diversity counting as a compelling interest in these upcoming cases. But it's more than that. Now I want to get again to your specific question. Even if you accept that educational diversity and assembling a diverse class of entering students can advance a compelling educational interest, it still has to meet the second prong of strict scrutiny. The second prong requires that you must advance that compelling interest through the least discriminatory alternative available. And here we get to a comparison between the Bakke case with a strict quota and the Gratz case, which they treated as a strict quota. To use an affirmative action program or to use race as one factor among many can be upheld, according to the court, in the Grutter case, as long as you really are treating individuals in a holistic fashion who have a number of aspects to them, including their religious beliefs or their political beliefs or what part of the country they come from or what type of life experiences they have. And race is just one factor among many. That can be upheld as a less discriminatory alternative than simply looking at someone and saying, that's a member of a race I want admitted into this class. You're no longer treating them as whole individuals. Now you're just looking at skin color. That is one of the most discriminatory ways to look at an individual. So in the two cases, in Grutter and Gratz, in Grutter, race was just used as one factor among many. But in the Gratz case, they gave so many points just on the basis of race. The court concluded that they were no longer treating these individuals as holistic people, but instead have reduced them to simply a racial group. And that's one of the most discriminatory ways to treat people. And so therefore, it violated the second prong of the strict scrutiny test.
That makes total sense. You make these very complicated things quite understandable. So on to the Grutter case, okay, which you mentioned is the case that now the court really relies on as the appropriate precedent when dealing with affirmative action cases. And I was reading the Students for Fair Admission versus Harvard and the Students for Fair Admission versus University of North Carolina cases, and as part of Harvard and UNC's defense, they went back to referencing the standard in Grutter. So can you please tell us, what is that standard that was established in this 2003 case that is now the precedent for affirmative action?
Of course. So in Grutter, in the majority opinion written by Justice O'Connor, once again, it was a use of racial classifications by the government. So according to O'Connor, it had to meet strict scrutiny. That continued to be the rule after Brown and after Loving and after a whole line of cases decided by the Supreme Court. But in applying strict scrutiny, Justice O'Connor deferred to the university's decision that educational diversity was important to the point of being compelling. In other words, without a sufficiently diverse class, the educational mission would not be properly or adequately advanced. And so part of the way Grutter approached strict scrutiny was to defer to the school's own decision and own definition of what counts as educational diversity, and also deferred to the university's decision as to what kind of racial makeup would sufficiently advance educational diversity, and how many admissions from Black Americans or Native Americans or Hispanic Americans. All of this was left to the school itself to determine on its own and to come to its own conclusions about when the mix was adequate to achieve this compelling interest. So sometimes Grutter, the strict scrutiny advanced in the Grutter case is sometimes called Grutter strict scrutiny, because it's not at all the kind of strict requirement of proof and definition that the court generally requires when it comes to racial discrimination. In other cases, like a case called Parents Involved, which involved high schools that were assigning students to different high schools on the basis of race in cities like Seattle, Chief Justice John Roberts wrote the opinion, or one of the opinions, in the Parents Involved case. And the court in that case applied real strict scrutiny. They wanted to know exactly what type of empirical evidence the state had managed to come up with to explain what kind of educational advance you would get if you had this percentage of white students and Black students, and how much of an educational advance would be reduced if you had that percentage. And of course, the state couldn't meet any of that empirical evidence whatsoever. So according to the court in Parents Involved, it was an unjustified use of racial classifications. Grutter did not require universities to make any kind of empirical showing whatsoever regarding what exactly they were trying to achieve and how much they actually achieved through their particular program. So the Grutter approach is a kind of form of soft strict scrutiny, or Grutter-style strict scrutiny. And one additional aspect to the Grutter approach was Justice O'Connor's final statement in her opinion, that she understood that the case law required any use of race to be temporary, and that it was her expectation and the expectation of the court that these type of racial preference programs would end within 25 years. And we're now 19 years out from that decision. And the question of whether or not they will ever end, of course, was part of the oral arguments in this case that were held just back in October, I believe.
That is a perfect segue, Professor Lash. I was just about to ask you about that famous remark by Justice O'Connor. So I understand that her saying this in an opinion isn't bound by law to be enforced, but do you think that the court in this term will take her opinion into consideration? And was that statement merely Justice O'Connor's opinion, or was she referencing something that her colleagues on the court kind of collectively understood when handing down the Grutter decision, that it would be temporary? The exact quote, just to tell the audience, is, quote, "We expect that 25 years from now, the use of racial preferences will no longer be necessary to further the interest in student body diversity approved today."
Well, I think there are two ways to think about that. You're absolutely right to say that there isn't anything written into law that requires affirmative action programs to end after 25 years. And I don't think she She was making a statement that everything had to come to an end 25 years out. But from another perspective, she was stating legal doctrine when she made that statement. And here I want to back up a little bit and talk a little bit about why we're applying strict scrutiny in the first place. According to the court, the whole purpose of the Equal Protection Clause and the passage of the Reconstruction Amendments was to stop the government from dividing its citizens on the basis of race, that there's something particularly poisonous to the body politic when you treat people that way, regardless of their race, whether they're a member of minorities or majority groups. The court concedes, as it does in almost all doctrines, that sometimes a particular right or a particular requirement has to give way because of an emergency. And you have a freedom of speech, but there's some ways that freedom of speech might have to be abridged if we're talking about libel or some type of dangerous incitement or something along those lines. And it's the same thing when it comes to the general prohibition on using race. There might be some emergency situations where the government would be justified in doing something that actually does impose harm, but it's needed for a short period of time. But in allowing it, the court has required that any such use of race be temporary and have an endpoint associated with whatever they're doing, because no program that uses race avoids imposing this type of dangerous harm in terms of how we view each other as citizens. So in the affirmative action cases, and there's been a long line of them, Adirond and a number of them, Croson and others, the court has always said whenever the government uses some type of racial classification, it has to explain when it's going to end. If you're going to divide prisoners due to a race riot, as soon as the physical danger is past, you're required as a matter of law to reintegrate your prisons. We can't have ongoing segregated prisons. So in her opinion in Grutter, when she said, we expect that these programs are going to continue to be temporary, she gave an estimate about what she thought was going to be a sufficient time period for the use of these racial preferences to come to an end. But even if the 25-year period was simply her estimate, the idea that these programs must have a definable endpoint is part of already established doctrine. And this came up during the oral arguments in the Students for Fair Admission cases, both Harvard and UNC, where members of the court questioned the lawyers as to when are these programs going to end, and have you structured them with the expectation that they will have an endpoint due to the danger of using racial classifications.
It is very interesting that I did not learn, at least to my recollection, in my constitutional law class, that it is part of the doctrine, as you say, to specify when these racial instances of dividing or discrimination are going to end. I never knew that. So let's talk about some more of the specifics of these two upcoming cases that you just mentioned, Students for Fair Admissions versus Harvard and UNC. Can you please provide us with a synopsis about the challenge being presented?
Sure. So there are two consolidated cases, one involving a racial preference admissions program at Harvard University, which is a private institution, and one involving a racial admissions program at the public university, University of North Carolina. The challenge brought by an organization, Students for Fair Admission, in terms of Harvard, alleges that their program violates Title VI of the 1964 Civil Rights Act, which forbids racial discrimination in any educational program that receives federal funds. The same organization is also challenging the racial preference program at the University of North Carolina, alleging that program violates the Equal Protection Clause of the 14th Amendment. They can be consolidated because in past precedents, the court has concluded that the requirements of Title VI of the Civil Rights Act require the same type of non-discrimination approach that the Equal Protection Clause also requires. So they can use the same kind of strict scrutiny and determine whether or not Harvard is violating Title VI or the University of North Carolina is violating the Equal Protection Clause. There's a little bit more. There are some factual distinctions between the two cases. Part of the allegation at Harvard is that the admissions program discriminates against Asian Americans, and leaves them at a significant disadvantage in terms of their opportunity to gain admission into the class. Whereas that's not part of the specific allegation in North Carolina. That is simply you're using race, you haven't met strict scrutiny, therefore it should be invalidated.
Isn't Harvard allowed to practice whatever affirmative action policies that it wants because it's a private university? I understand the challenges with University of North Carolina because it's public, but why does Title VI of the 1964 Civil Rights Act apply to Harvard? Well, I guess Harvard takes some federal funding, but then why is it called a private university?
Well, it's a private university that can decide whether or not it wants to receive federal funds. And federal funds, the federal government can impose conditions on the funding that it gives to educational institutions. And in this case, under Title VI, the government said, listen, if you want to go your own way and have whatever your requirements are, fine. But if you're going to receive federal funds, as part of the civil rights movement, we're going to say that federal funds are only going to go to institutions that stop discriminating on the basis of race. So Harvard could, I mean, if Harvard, say the court concludes that the Harvard program violates Title VI of the Civil Rights Act, it would be an option of Harvard to say we're going to continue to do the same program. We're just no longer going to take federal funds.
Got it. Okay. So I understand now why the Harvard case, the Civil Rights Act is in question, but then with the UNC case, the Equal Protection Clause, I was thinking, why the difference? Why not any consistency? So here in this Harvard case, one of the big scandals was that Harvard apparently consistently rated Asian Americans lower than other applicants on positive personality traits. These include likability, courage, being widely respected, leadership. Is it Harvard's prerogative to do that? In other words, is this a credible claim of discrimination on the basis of race?
Well, if they're going to receive federal funds, they cannot discriminate on the basis of race. And Students for Fair Admission are making the claim that Harvard is discriminating on the basis of race in two separate ways. One way is the simple use of race, period. And the fact that some people, some applicants on the basis of race are being treated different or given certain advantages that other members are not. But in addition to that, they're also saying there also is a particularly virulent form of discrimination going on in the Harvard program, whereby Asian Americans, who, according to the scores that they produced in litigation, as a group scored very highly and would otherwise, if they were part of a targeted minority group, would receive almost presumptive admission. Yet for some reason, they're not being admitted. Why? Well, according to the evaluations of the people determining who's going to be admitted into Harvard, their evaluations contained very low personality scores. And according to the plaintiffs in this particular case, that represents either an invidious stereotype against Asian Americans, or it's simply a cloaked attempt to find some way to suppress the admission numbers of an otherwise very highly credentialed group who would receive significant numbers of offers of admission. So one way or another, the claim is they're being treated differently and being treated negatively, either as an attempt to keep down their numbers or due to a stereotype of Asian Americans, or both. But both would be forbidden by Title VI of the Civil Rights Act.
One of the other things that came out in this Harvard case is that Harvard, and it seems like other private institutions, evaluate applicants against other fellow members of their racial group. So when they're evaluating Asian American applicants with test scores, they compare them to other Asian American applicants. And as we know, Asian American applicants to universities generally tend to have higher test scores than other racial groups. So is that evaluation, Asians against Asians, white people against white people, black people against black people, does that constitute racial discrimination?
Any kind of grouping of individuals on the basis of race is going to be racial discrimination. And if you're a government institution, you're going to automatically face strict scrutiny anytime you use that type of classification. If you're a private institution and you are making that type of grouping evaluation on the basis of otherwise protected classes, you're going to face Civil Rights Act restrictions, such as Title VI. The question becomes, in all of these cases, whether or not Harvard can say, yes, we do that. We recognize that we are seeing people as members of particular groups, but we do that in order to advance an interest in educational diversity, whereby we want some members of our admitted class to be Asian Americans, or maybe Black Americans, or Hispanic Americans, or people from the West, or people from poor families, or people from wealthy alumni, or people with athletic abilities. In other words, they would simply concede, yes, we are using racial classifications. Yes, we are discriminating, and that's really all discriminating means. I'm taking notice of and acting upon my identification of you as a particular group. But remember, Harvard is claiming that they are justified. They're not denying that they do this. They do deny that there's any type of stereotypical treatment of Asian Americans, and that's part of the litigation. And if I had to make a prediction, I think the Supreme Court is going to avoid that particular issue. Justice Gorsuch might want to talk about how Harvard used these holistic admission programs in decades past to discriminate against Jewish Americans, and they appear to be doing so again in terms of Asian Americans. I suspect that the court will come to a decision that treats the Harvard case and the University of North Carolina case as both representing forbidden uses of racial preference programs, and they will avoid accusing Harvard of being hostile to Asian Americans. But it is part of the context of the case that makes it especially troubling.
Again, it was a perfect segue because I was going to ask you what your predictions are. Just quickly, before we move on from these affirmative action cases, I want to make sure that we have enough time to discuss the 13th Amendment and then the Creative 303 free speech case. With the case of the University of North Carolina, and I guess with this Harvard case, what really makes their practices different than what was allowed in Grutter? I'm still a bit unclear, because if the court has previously ruled that as long as these universities are not, abiding by quotas, that taking race into account is okay, then really what's the challenge? I understand what we were just discussing with the possibility that Harvard may be using a stereotype, when evaluating, Asian American applicants, but assuming that is disproven, and it may not be, again, what are the practices that are unconstitutional?
It's a great question. I think that the big difference there, of course, would be the allegation of discrimination against Asian Americans. Mm-hmm. I think there's been a concern for many years that certain high-performing groups were being discriminated against, or were facing particular hurdles in getting the same opportunity to be admitted into classes at top-end colleges and universities. So the fact that there now appear to be empirics, really specific evidence, and numbers that do suggest something needs to be investigated here, that is different than what was in the Grutter and Gratz case. But other than that, when it comes to the University of North Carolina, I can't identify anything that's particularly different about the North Carolina case and the Grutter case, beyond the fact that we have a completely different court. You have all of the justices that were in the Grutter majority are no longer on the court. They've either passed away or they've retired, and instead the court majority now seems to share the opinion of Justice Thomas, or the opinion of Chief Justice John Roberts, who's been very clear in his skepticism of racial preference programs. And so this may be a case where the court is simply going to reverse. It's going to overrule the Grutter case and say that we were wrong. We had hoped that there might be a way to go forward with this particular approach, but we now realize there isn't any way to justify these kinds of programs. And just as they did with the Dobbs case, and say for a while we were under the Roe and Casey regime and the undue burden test, and we've now come to the conclusion that they're not constitutionally justified, and they aren't justified in terms of stare decisis in being maintained. And so therefore, just as we overruled Roe and Casey, we hereby overrule the Grutter approach.
This is going to be one of the most colossally obvious statements to you, but I have just come in recent years to really gain an appreciation for how important the Supreme Court is in the making of law in this country. I just, in high school, I didn't really consider that they played as big of a role as they do. And to really get nerdy, one of the things that and I wasn't even planning on asking you this, but it just came to mind when you were saying how much the court has changed. One of the things that I thought was so interesting in my constitutional law class in college was the Marbury versus Madison case. What was that, 1803?
Yep. Yes, it was.
I'm just showing off now.
Good for you. Good for
no,
you.
I have a weird memory of dates. And that was the case that established judicial review. It established the court's role that it exercises now, and obviously it has exercised since then, where the court can determine whether statutes are constitutional or unconstitutional. And it kind of hit me in the class. This is, this role of the court exercising judicial review is not outlined in our Constitution. So what would the role of the court be if not exercising judicial review? Interpreting statutes?
Well, it is judicial review, and it's, that's kind of legal term of art. It sounds so soft and gentle. We're just reviewing justices. But of course, it means much more in the American system of constitutional law. The phrase judicial review involves the power of the courts to review and invalidate any actions by government officials that are inconsistent with the Constitution. It's an unusual approach to constitutional government, and one that is very rare in constitutional and political democracies around the world. And we're often challenged as a country to explain why we have given such authority to our court to strike down laws that are otherwise passed by the people's representatives. And if the people don't like the laws, they can throw the bums out at the next election cycle. And the justification under the American system is that the court must invalidate any law which is inconsistent with the Constitution, because the Constitution was created by the people themselves, the sovereign people of the United States, and done so under extraordinary circumstances that require a supermajoritarian vote before anything gets entrenched into the Constitution. Well, faced with that type of supermajoritarian document, that document is superior and is democratically superior to any kind of one-time vote by the legislature of Massachusetts or a school board somewhere in Topeka, Kansas, or something along those lines. So we justify judicial review because we trust that the court is enforcing the will of the people themselves. But we hold the court accountable to do just that, and not to impose their own personal preferences on the democratic regime, but instead to hold themselves to their oaths of office and to enforce the Constitution as that Constitution was understood by the people who actually adopted it.
Right. It's very interesting. Now, moving on to my question for you about the 13th Amendment. As I indicated a few minutes ago, the 13th Amendment has really come into a lot of our national conversations in the wake of the race riots in the summer of 2020. And people have argued that the punishment clause of the 13th Amendment allows slavery to still exist for prisoners. I'm just going to read the text here of the 13th Amendment. So the 13th Amendment abolished slavery, but then there is this tricky clause here. It says, neither slavery nor involuntary servitude, except as punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Can you please explain the meaning of that punishment clause?
that tricky punishment clause, I think, was the word that you just used. And
Very
of course,
tricky.
documentaries like 13 and other critical race theorists view that clause in the 13th Amendment in exactly that way, as a kind of trick, whereby it appears that slavery has been abolished, but we can impose slavery by other means. That is not at all why that clause is there. And the story about how it got there is quite extraordinary. And so hang on. I'm going to take you through the history of the 13th Amendment.
Please
And
do.
in doing so, we've got to go back just a little ways. I mean, now we're really into my wheelhouse as a constitutional historian. Slavery, of course, is an issue even before the adoption of the American Constitution. Slavery is an issue even before the American Revolution. British government permitted slavery in all of the 13 colonies. It wasn't until the Revolution that American states finally became free to move in the direction of abolition. And in fact, the northern states did so immediately, as soon as the revolution. And in fact, Pennsylvania had already started the first abolitionist society even before the revolution. So upon breaking away from Britain, we're now in a position where states can make the decision themselves as to whether or not to abolish slavery. Northern states move in that direction. Southern states continue the old colonial practice of slavery. But northern states deepen their commitment to abolition through the adoption of the 1787 Northwest Ordinance. The Northwest Ordinance, which covers a territory which now are states like Wisconsin and Michigan and Indiana and Illinois. Title VI, or Article 6 of the Northwest Ordinance, banned slavery in the Northwest Territories. It did so in language that was drafted by Thomas Jefferson himself. And let me read you the language of Article 6 of the Northwest Ordinance. There shall be neither slavery nor involuntary servitude in the said territory, other than in the punishment of crimes, whereof the party shall have been duly convicted. That was a recognition that there is such a thing as hard labor, that when you're convicted of a crime, regardless of your race, you can be put to labor for the uses of the state. But slavery, chattel slavery, buying and selling of individuals, whereby their children also became slaves upon birth, that was now prohibited in the northern states. Then, as you move towards the adoption of the Constitution becomes a federal document that once again allows northern states to continue to move in the direction of abolition, and they do, and also allows southern states to move in the direction of maintaining or even deepening slavery, which they do, of course, after the invention of the cotton gin. But it led to this dispute between the time of the founding and the time of the Civil War as to whether or not our country was fundamentally pro-slavery or whether or not our country was fundamentally pro-freedom. And according to southern states, we were a pro-slavery government. We were a government that was committed, its constitution was committed, and its historical traditions were committed to white supremacy and to blacks being treated as a form of property. But according to abolitionists in the North, that wasn't true at all. Thomas Jefferson had drafted the Declaration of Independence, which declared that all men were created equal, regardless of color. And do you know who drafted Article 6 of the Northwest Ordinance? Thomas Jefferson, who moved in the direction of abolition in the North. Slave and slavery wasn't included in the Constitution. Instead, they adopted the Due Process Clause that said that no person could be wrongfully deprived of life, liberty, or property. And so abolitionists and Republicans in the North developed the argument that the Constitution was tilted towards freedom and not towards slavery. When the Republicans won the election of 1860, of course, they elect Abraham Lincoln. Abraham Lincoln, just like Frederick Douglass, shared a pro-freedom reading of the Constitution. He insisted that slavery would have to be abolished in the territories and that northern states should be allowed to continue to deepen their commitment to the eradication of slavery. That was not acceptable to the southern states. They secede, and we have a civil war. During the Civil War, Republicans immediately abolished slavery in the territories, regardless of the holding in Dred Scott. They abolished slavery in the District of Columbia. Lincoln he issues the Emancipation Proclamation. So everything is moving in the direction towards freedom in the North, but we still need more. After the Civil War, it was possible that Individuals who had been freed under the Emancipation Proclamation might be returned to slavery in the South. And we still had loyal border states which allowed slavery, even though they didn't secede from the Union. So if slavery was going to be abolished, it was going to have to be through an amendment that eradicated it throughout the country. So the Republicans proposed a new 13th Amendment. And in proposing it, they explained that this amendment was not changing the thrust of the American founding or the American people. It instead was fulfilling a promise that had been there all along. And the way they supported that argument in drafting the 13th Amendment was by using the language of the Northwest Ordinance. Here's the 13th Amendment. Neither slavery nor involuntary servitude, except as punishment for a crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. They used the language of Thomas Jefferson's ordinance, and they did so in order to support their argument to the people that we have always been tilted towards freedom. Thomas Jefferson, therefore, is 3 times responsible for the movement towards abolition: the Declaration, the Northwest Ordinance, and his language being used in the 13th Amendment. The problem comes after the Civil War and after the adoption of the 13th Amendment, when the Southern states they enact the Black Codes. The Black Codes impose particular civil rights disabilities on Black Americans, deny them the opportunity to pursue a trade, deny them the opportunity to own property, give them extraordinary punishments beyond those imposed upon white people, and in particular imposed vagrancy laws, whereby if a Black American didn't have a visible means of support or a job, they could be arrested, and then after they're arrested and convicted, they now could be sold out as convict labor, as involuntary servitude, and in many cases could be sold right back to their former owner. That was the purpose, to eradicate those kinds of laws. That's why we had the Civil Rights Act of 1866, which abolished discriminatory treatment, gave Black Americans an equal right to own property, to pursue a trade, abolished differential punishments on the basis of race in order to eradicate those particular Black codes. So whatever the documentary 13th might say, or whatever the 1619 Project might say, that this was some type of tricky provision placed into the 13th Amendment to maintain slavery, it's exactly the opposite. They used that language because it was foundational to the idea that America, from the very beginning, had been moving towards abolition.
I would like to arrange for your speaking tour in public schools throughout the United States. Wow, this is, to state the obvious, it's why it's so important to know history. I remember I watched that Netflix documentary back in 2020, and they argued just what you said, that it was kind of snuck in there to persecute people in prison. And obviously the makers of the documentary went even a step further to say that they try to disproportionately incarcerate Black people so that they specifically will be subject to this provision. Do you see an argument that this should be eliminated, that this is no longer, I guess, relevant, or it can be misused?
Well, the idea of whether or not hard labor is an appropriate form of punishment, I think is a great argument, but it's not one that I think is traced along racial lines. Since you can follow under common law the use of hard labor into a variety of cultures regardless of race, it's something that's always been there. It can be used in a racially discriminatory manner, and that, of course, is why you have amendments like the 13th Amendment and the 14th Amendment, which prohibit unequal application of the laws and unequal punishments. And I think we have to always be attentive to the possibility that Black Americans or any number of disfavored religious or political or racial groups are being subjected to disproportionate application of the law. I think that's a very serious issue, and it's one that we're going to have to be constantly vigilant about. But the idea as to whether or not people who have been convicted of crimes can be recruited to do certain forms of labor, it's a separate issue. It's an important issue, but not one that I think is necessarily tied to slavery.
Understood. So moving on finally to this Creative 303 case. I am not going to go on a rambling rant to explain the background of the case as I did with the 1978 UC Regents one. So instead, I would like to ask you, can you please provide the audience with a synopsis of the facts of the case? And maybe also, if you could talk about how this relates to the wedding cake case, that would be very helpful too, because this is a wedding website case. Yes, masterpiece.
Right. Okay, well, of course, I'd be happy to.
Thank you.
And here's the way they link together. Colorado. The Colorado Civil Rights Commission,
yeah, you're right,
and the application of its anti-discrimination laws. Yes, we had an earlier case, Masterpiece Cake Shop, in which Jack Phillips did not want to design a case for a same-sex couple. He was convicted of violating the anti-discrimination laws by the Civil Rights Commission of the state of Colorado. He claimed that he should have a free exercise and a free expressive right to determine what ideas by way of art, in his way, of course, it is a baking art and the use of bakery goods to celebrate, to communicate particular ideas. And he claimed he was being forced to do something that violated his beliefs. He was forced to celebrate something that he didn't believe was appropriate to be celebrated. Now, it went before the Supreme Court in the Masterpiece Cake case, and the court avoided the issue as to whether or not individuals should always have the right to create whatever bakery goods they wanted to. Instead, the court in that case discovered evidence of religious animus, particular statements by the Civil Rights Commission that were clearly discriminatory and disparaging of conservative religious beliefs. That is always in violation of the Free Exercise Clause. This new case is a little bit different. In this particular case, you have Lori Smith, who wants to expand her website design business to include wedding websites. And she is aware that the Colorado Civil Rights Commission has been enforcing its anti-discrimination law. And she's a religious individual who wants to design websites for opposite-sex couples. And same-sex marriage is against her religious beliefs. And so she has gone to the courts seeking an injunction against the application of Colorado law if she continues to just design websites for those who are opposite-sex couples. So there's no evidence in this case of religious animus. There's simply the straight-up issue as to whether or not someone who engages in website design can be forced to create websites that are celebrating issues and ideas and beliefs that the website designer does not share. And according to the plaintiff in this case, the government cannot force you to speak. And her designing websites and celebrating and creating a website that celebrates the message of marriage, she wants to be able to communicate marriage as she believes marriage truly is, and forcing her to create a website for same-sex marriages would force her to say things that she doesn't believe. And there's a long line of cases whereby the government has been prohibited from forcing people to speak. This goes back to forcing Jehovah's Witness children from speaking the Pledge of Allegiance in schools back in the Barnett case. There also were cases in the 1990s where parade organizers could not be forced to include a gay rights float because they were communicating a message through their parade, and they should be able to control what components of that message they wanted to include, and the government couldn't force them to include messages that they didn't want to include. And so in this case, the plaintiff is saying this is the same thing. I'm engaged in artistic communication of celebrating my ideas of marriage, and you cannot force me, therefore, to celebrate marriages that I do not accept. The court is going to have to, therefore, treat this case as a freedom of speech case. There's no evidence of religious animus, so it's going to be whether or not designing a website for weddings is an issue of speech, and if it is an issue of speech, whether or not the state can require her to speak the message of celebrating marriages regardless of the people being married.
What's so interesting about this case is that it's not a clear-cut speech case because, well, this one with the website and then the Masterpiece Bake Shop one too, they're both something creative. And so it raises the question, you know, is a creative expression like baking a cake or designing a website in a different category than speech? And the thing that comes to mind when I read these cases, and I understand that it may be different because this doesn't specifically apply to a freedom of religion issue, but let's say there's a Jewish baker. Would he have to be forced to bake a cake with a swastika on it, according to the challenge being presented here, that you have to abide, or you can't discriminate basically on someone who comes into your shop? In other words, where is the line that can be drawn, or is there no line?
Right, that's the difficult issue in this particular case, where to draw the line. I think the court, and even the liberal side of the court, who might otherwise be in favor of upholding the anti-discrimination law, all of the justices understand that the government cannot force you to speak. And so the issue in this case is going to be whether or not there is speaking. And there's a long line of cases that accept the fact that you can communicate in a variety of ways, including symbolic ways. And you can communicate. I think in the State of the Union address just last night, I think that some members of Congress were communicating symbolically by maybe wearing a Ukraine pin of the colors of the flag of Ukraine. There are lots of forms of symbolic expression that are communicating and are understood to be communicating a particular message. And we cannot be forced to communicate those kinds of symbolic messages if we don't want to. But the liberal side of the court in the questioning during oral argument was also concerned about anti-discrimination law. Are you saying, therefore, that if we're going to protect the right of a Jewish baker to not have to communicate the symbol of racial hatred in the form of a swastika, could a swastika-minded baker refuse to serve a Jewish patron? And so the court's going to have to distinguish between a simple denial of service, in other words, a baker who has a bunch of muffins and is refusing to sell those muffins to someone because of their religious beliefs or their race or something along those lines. That will probably be continued to be subject to anti-discrimination laws. You cannot simply deny service in your restaurant or your construction company simply because of someone's race. But if what you're offering is not simply a good, simply a non-expressive good or service, but actually involves you saying something, communicating something, they've come to you because they like your words of expression, they like your ideas and your beliefs and the way you express those beliefs, can you be required to express those beliefs even to the Ku Klux Klan or even to Nazi Germany or whatever it is, or a pro-Trump cake? I mean, it can be any one of a number of things. The court's going to have to decide how to protect people in their expression, while at the same time protect patrons who don't want to be denied service simply because they're a member of a group, a racial, religious, or sexual orientation.
It's very interesting because the way the Civil Rights Act is written is that it says that you cannot discriminate on the basis of race, color, national origin, etc. But it doesn't define, I guess, in what way you can't discriminate. As you say, there's non-expressive goods, and then there's a creative masterpiece that's a cake. It's very, very complicated and interesting. I do want to ask you a bit about these anti-discrimination laws and the constitutionality of them in the first place. So let's look here at the Colorado Anti-Discrimination Act, which is here at play here in this case. It says that it prohibits businesses that are open to the public from discriminating on the basis of numerous characteristics, including sexual orientation. The law defines discrimination not only as refusing to provide goods or services, but also publishing any communication that says or implies that an individual's patronage is unwelcome because of a protected characteristic. Now, I read Christopher Caldwell's book, Age of Entitlement. I don't know if you're familiar with it. And he talked about, in the first few chapters, the Civil Rights Act. And he challenged the constitutionality of that act by referring to our right to freedom of association that he says is implied in the First Amendment. What is that argument? I never really understood the way that freedom of association is implied in the First Amendment. And the reason why I'm asking this question, just to make it quite clear, is that, you know, if we do have a right to freedom of association, essentially to discriminate, you know, who we let into our business, what business we go into, then that would make the Civil Rights Act and this Colorado Anti-Discrimination Act and other anti-discrimination statutes unconstitutional.
It's a great question of drawing lines, and it's interesting that you raise that subject. It's part of a speech I was just reading by Frederick Douglass. Douglass understood that he was calling for an expansion of civil rights and the ability of African Americans to enter the public sphere and do so on conditions of equality with other citizens of the United States. But in doing so, he also recognized that there is a certain private sphere which should be on government control. And so he talked about the difference between what happens when you go out into public and you board a trolley car, right? Or you want to board a steamship, and you might face discrimination out there, and how wrong it is for Black Americans to be discriminated against out there. But he also said, in terms of my own parlor, I get to invite whoever I want to and exclude whoever I want to in my own parlor. And I can do so on whatever conditions I want to. What I tell my students, I'm Mexican-Irish. And I tell my students, as far as the Constitution is concerned, it can't reach my decision to hold a Mexican-Irish party at my own home. But the distinction there, and so that's my right to assemble, my right to congregate, maybe my right to gather with other religious believers, right, or things along those lines. But when we enter the public, now it becomes a situation on whether or not we're treating each other as equal citizens. It's no longer a situation of private association. Now it has to do with whether or not people are being disadvantaged in their ability to flourish as citizens of the United States. And so the law draws a distinction in terms of private associations where you can make your own decisions and whether they're tied to your racial makeup or your religious makeup or your political beliefs. Private associations are protected against anti-discrimination laws. But when it comes to public offerings, when you're entering into the commercial sphere, at that point, the government's going to be able to set the conditions of equal treatment and equal citizenship. Drawing the line in terms of where that distinction occurs and whether or not the line's been drawn appropriately to continue to protect freedom of speech and religious association and other forms of political association is an issue that's constantly before the court. But the court continues to maintain that line, the idea that we do have constitutional rights to our private religious beliefs, our private political beliefs, our private association. But at the same time, when we exit that private sphere, now we have common obligations of citizenship.
It's very interesting because you, as a owner of a bakery, may be subjected to these anti-discrimination acts, but you as a patron of a bakery are not. If you walk in to a hotel or a bakery or any kind of business as a patron and you don't like the race of the person behind the counter, or you don't like the look of the person behind the counter, or you don't like the smell in the shop, or, you know, for any number of reasons, you can turn out and walk out of there. But then the person who is serving you cannot, for obvious reasons. Anyway, I think that is
to a certain degree. Again, if what you're offering is an offering of your expressive talent, you are going to be able to, well, I suspect the court is going to protect that right in these cases. But you're right. If it's a non-expressive offer of services, then yeah, you are subject to non-discrimination laws. Whereas private individuals are allowed to make their own decisions about where they want to shop and where they don't want to shop. There are some restrictions on that as well. If you're selling property, you cannot discriminate. In terms of contracting, there are certain restrictions on whether or not you can discriminate on the basis of race or other protected classes. But generally, you're right. Private individuals can decide whether or not to enter the commercial marketplace, and they can stay out of it if they want to. But those people who have set up business in the commercial marketplace, as long as they're not involved in any type of First Amendment protected expressive activity, they are subject to anti-discrimination laws.
Professor Lash, thank you so much for coming on to the show. You've been so generous with your time. And as I said, I love speaking with you because you make all of these very complex subjects really clear. And, you know, a lot of Americans, we don't pay a lot of attention to the Supreme Court because so much of it is complicated. But it's really nice to have someone like you who makes the information accessible to all of us, because this is our country. This is our future. These are decisions that are going to be impacting all of us. So thank you very much. I hope that you will come on again and we can get into even more cases and the history of the 13th, 14th, and 15th Amendments.
Julie, it's been a pleasure. I would love to come back. And let me just say that you are also important. What you are doing in offering a presentation where people can come and get ideas and hear perspectives that they might not hear from other media sources. I think you are incredibly important to the ongoing conversation and civic project of American freedom. So thank you, and I'd be happy to come back.
That's very kind of you to say. Let me tell you, though, I was thinking towards the end, do I want to become a Supreme Court justice? Because, my gosh, there's a lot of stuff that you have to weigh, a lot of conflicting things. So I have gained respect for them throughout this conversation. We'll talk soon. Thanks so much.
All right. Thank you. Take care.
I appreciate your joining us today, and remember that each of our thoughts, choices, and actions shape who we are. So let's think clearly, choose wisely, and act with principle and determination. Take care.